from the NewsChannel 5 Network. This is the Takis McGinnis Elder Care Law Hour.
Welcome to Takis McGinnis Elder Care Law Hour, where we explore the many issues that arise due to aging, disability, and long life. I'm your host, Tim Takis.
And I'm Barbara McGinnis. In today's episode, we're going to be talking about how the judicial system becomes involved in elder care issues. Specifically, we're going to talk about conservatorships, probate, and mediation. We're going to start with the concept of probate, something many people have heard about and really few people understand. With us today is Judge Randy Kennedy from the 7th Circuit Court. And welcome, Judge Kennedy. And we're going to talk about probate.
Well, thanks for having me. I appreciate you inviting me to be a guest on your program.
Thank you. So, what does probating a will mean?
Well, you know, in the literal sense, we first need to recognize that a will is a futuristic document. It really doesn't take effect until the author of that will, who we call the testator, has actually become deceased. So upon the death of an individual who has in fact written out a will or prepared a will, the probating of that will is the opportunity for the court and the family to test the authenticity and the legitimacy, the validity, as it were, of that document. So that's the step that happens when someone probates a will.
So there's like a piece of paper and somebody takes it to you and says, this is Mama's will, and you say, oh, I guess it is, isn't it?
Well, it's a little more specific in terms of the foundational requirements than I guess it is.
Right.
But in fact, that is the way probate operates throughout the state of Tennessee. If someone brings you the document that purports to be the last will and testament of a decedent, it's up to the judge as the trier of fact to review that document and to look at the case law and the statutes to see whether or not it's in compliance with our legal requirements in Tennessee. And if it is, then that will is actually admitted to probate, as it were,
So do all wills go through probate?
You know, not every will is presented to probate. For example, if an individual were to die owning nothing, let's say they had no personal or real property, or if everything they owned was jointly owned with a surviving spouse or another family member with a right of survivorship, then those are a couple of reasons why you might not probate a will. Generally speaking, however, most wills are submitted to probate.
Well, tell us more about the assets that actually go through probate. You talked about joint tenancy, no probate.
Right.
Right of survivorship, no probate.
Right. Fundamentally, the assets that are required to be presented to probate are those assets that are solely in the name of the decedent. For example, if an individual owned real property solely in his or her name, or had a bank account with no payable on death beneficiary, or jewelry, or cash, or personal property, stocks and bonds, things of that nature, they might very well need to be presented to probate. And quite frankly, and ironically, even though jointly owned assets are not required if they have a designated beneficiary, it's been our experience that many banks, many brokerage firms, and many other financial institutions require you to probate the will and get the issued letters testamentary before they will, in fact, transfer or liquidate the jointly owned assets. And that's unfortunate, but that's the distinction, is jointly owned versus solely owned.
You know, a lot of people really don't want to go through probate. Is that a good idea to try to avoid probate, or when should people go through probate and when should they not?
Well, occasionally, let me say this, that the devil's in the details. For the vast majority of folks that I have come in contact with during the 14 years that I've been on the bench, having a last will and testament and probating your estate is a fairly smooth process, especially if the family's not fighting over anything. Unfortunately, there are some unique cases where either the estate is extremely large or extremely complicated, where an inter vivos or an irrevocable trust may be in order, or where it may be appropriate to transfer assets during your lifetime so as to avoid probate. I've got to tell you, however, that simply doing something to avoid probate generally is a bad idea.
Okay. So is there a time limit on probating a will?
You know, when I first took the bench, Tim, and I bet you and Barbara may have thought the same thing, I was under the impression that there was a statute of limitations that required you to present a will within a specific period of time. Because of the Mary Reeves Davis case, which I had the opportunity to probate, and which began under my predecessor, Judge Frank Clement, literally more than 17 years ago. When a will is found or discovered many years after the death of the decedent, that tolls the running of any kind of a statute, and in fact, there's no statute, according to the state Supreme Court, over when you can present a will. You simply should do so within a reasonable time after it has been discovered.
Okay, so we know a will was going to go through probate.
Right.
Most of the time. It's not particularly difficult or onerous to do so.
Right.
But does a family need an attorney to go through probate?
Well, that's an interesting question. When I first took the bench, I was under the impression that everybody should have a lawyer in every situation. We asked for an attorney general's opinion back in 2005, and the state attorney general at that time wrote an opinion which is not binding upon the courts, but which is advisory. That attorney general's opinion reminded us that self-represented litigants do have the right to file petitions, do have the right to present documents to the court without the benefit of an attorney. Notwithstanding that advisory opinion, it's been my experience that people generally fare much better and they are a whole lot less confused and traumatized if they have beside them a good lawyer who knows what they're doing.
Yeah. Sometimes we'll tell families that if it's a small estate administration, that's certainly something they can navigate
That's true.
without attorney representation. But if it's what we call full-blown probate,
Right.
that obviously we would recommend that someone would have an attorney to walk them through that process, because the court's job is not to give legal advice. You're really in a spot where you can't give legal advice.
But I really can. And you know, a lot of folks don't realize that once a lawyer becomes a judge, his ability or capacity to practice law comes to an end. And so while you may make a directive from the bench, you really can't advise them. And of course, this brings itself up in what we call small estates, as you said. Estates valued under $50,000 can be presented without the assistance of counsel. But even in those cases, very often the individual who files it, the surviving spouse or family member, comes in with a world of questions, and quite frankly, in those cases, I have to refer them to lawyers like yourself to say, you need to go see an attorney and see if you can't get some assistance on this.
So we've just got a couple of minutes left. So now someone is named an executor or a personal representative, you know, in a will. So what's the first step for them?
The first step that I advise anyone who's been named an executor is to call an attorney to get additional advice on the numerous items that must be accomplished. Secondarily, there are three basic things an executor's got to do: marshal all of the assets or preserve the assets, pay the valid debts of the decedent, and then ultimately distribute the net estate in accordance with the terms of the last will and testament. Those are the items that they've got, but first I'd call a lawyer.
Yeah, I remember your predecessor, Judge Clement, would always say, is being an executor is not a privilege, it's a job. And I'm sure that you probably say the same thing.
He was exactly right about that, and it is it's not an impossible task, but it clearly is an important and significant function to handle and to manage someone's estate.
Okay, well, thank you, Judge Kennedy. We are out of time for this segment. In our next segment, we will continue discussing with Judge Kennedy conservatorships.
All right.
So stay with us.